Hi, I'm Steve Schindler.
I'm Katie Wilson-Milne.
Welcome to the Art Law Podcast, a monthly podcast exploring the places where art intersects with and interferes with the law.
And vice versa. The Art Law Podcast is sponsored by the law firm of Schindler, Cohen & Hochman, LLP, a premier litigation and art law boutique in New York City.
Katie, what day is it today?
Steve, it's Censorship Day.
Wow, I've been looking forward to this for a long, long time.
Me too.
Today we're going to talk about art and censorship and the history of censorship in the United States in particular. And we know that artists often push the bounds of what is acceptable and dive deeply into areas that can be perceived as controversial. So today we want to talk about the free speech aspects of art and art as expression. That has a long history in the United States, going back even into the 19th century with the passage of the Comstock laws, which regulated the interstate transfer of materials that were deemed to be obscene. And certainly, historically, the United States has had a little bit of an obsession with obscenity, and particularly with materials that depict sexuality, and that has turned into a long series of Supreme Court cases, particularly in the 1970s and later, trying to define what fell outside of traditional First Amendment and what didn't. So today we're going to talk about censorship and what it means to suppress art and the expression that art contains, both from a government point of view, which implicates our First Amendment in the United States, and also from a broader social context today. So, Katie, could you elaborate on this a little bit?
So, traditional free speech concerns in the context of the First Amendment revolve around government censorship of private speech or art created and promoted by the public. But it's more complicated than that, or it certainly seems more complicated than that at this moment in time in the United States. So, on this episode, we want to dive into these issues and define what censorship means, when it is illegal, when it isn't, and why censorship of art may be different than censorship of pure speech or the spoken word. And while the law has a lot to say about when censorship of art can occur, non-government actors can also engage in censorship, but that is certainly not illegal. It still may be worth examining, however, in the context of our quote-unquote free speech society and public discourse. We will discuss these issues today with Professor Amy Adler, who is our esteemed guest.
We're here today with Professor Amy Adler. Professor Adler is the Emily Kempkin Professor of Law at New York University School of Law, where she teaches art law, First Amendment law, and feminist jurisprudence. Professor Adler's recent scholarship addresses an array of issues, such as the First Amendment treatment of visual images, the misfit between copyright law and the art market, the legal regulation of pornography, and the moral rights of artists. A graduate of Yale Law School, Professor Adler is a leading expert on the intersection of art and law, which is why we are so delighted to have her here on this podcast today. Welcome, Professor.
Thank you for having me. It's a pleasure.
So, Amy, we want to talk about art and censorship, and I think there's a lot of confusion in our culture right now about where the law intersects with concerns about censorship. So we'll try to tease some of that out with you, but first, why don't we start, if you could give our listeners an explanation of how censorship actually does intersect with the law, and what does the law have to say about censorship?
So the main text for thinking about this question is the First Amendment of the Constitution, and the relevant language from that amendment is Congress shall make no law abridging the freedom of speech. And interpreting what that means and how that applies has actually led to an enormous body of law that is actually quite a patchwork and actually hard to disentangle and means different things in different areas. I like to think about what Justice Brennan said, and if you could boil down what the First Amendment means. It's from a case called Texas v. Johnson, a flag-burning case where the court protected the right of dissenters to burn the American flag in a very controversial decision. And he wrote for the court, "If there is a bedrock principle underlying the First Amendment, it is that government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable." So if you can capture the principle, that's it, but just figuring out all its twists and turns and how it applies and then extending it to art will lead us down many, many different pathways.
So art is speech protected like any other kind of speech under that doctrine?
You know, it's actually a very difficult question whether art is in fact speech. And I think the Supreme Court has assumed it is. That assumption has arisen in a couple of places. For example, in obscenity law, the court has made an exception for things that are otherwise obscene if they have serious artistic value, suggesting that art is clearly protected under the First Amendment. The other place the court has assumed art is protected is in a case where they talked about the unquestionably shielded paintings of Jackson Pollock. But the reason it's an assumption and sort of a problematic one, as many scholars have struggled with, and some courts as well, is that it's kind of hard to think about art in the same way that we think about the sort of paradigm stuff under the First Amendment, which is political speech. You know, that's
Right.
somebody speaking and, you know, making a political assertion in writing or in language. That's obviously speech. An abstract work of art, what makes that speech is actually a much more difficult question.
Right.
So does it matter then what the subject matter of the art is in terms of whether or not it's protected speech? For example, would a landscape painting be some form of protected speech, or would it have to have some political or social content?
So scholars have debated this, and I think the answer is probably that all artwork is protected speech. And by the way, the Second Circuit has said that all art is protected speech. But the reason we protect speech is usually because it communicates an idea or communicates a political idea. And it's pretty hard to shoehorn things like abstract paintings or landscape painting into the language of ideas, let alone into the language of politics. And so one thing that I've thought about a lot in my scholarship is just generally the easier time we have in the First Amendment when we're dealing with text as opposed to images, because images just don't lend themselves as easily to this idea of, sorry to be redundant, the idea of ideas.
So in text, do you have the same question that is anything expressive protective, or does it have to have some viewpoint behind it, some political viewpoint? Obviously, when you get into the political realm, these are easier questions.
Yeah,
based on
I
how
think
laws
I
felt.
think speech does not have to be political to be protected, but it has to be recognizable as speech. And so there's sort of an interesting article recently where someone wrote about whether nonsense speech is speech, you know, text like Jabberwocky or something. So these are sort of interesting, I guess, side questions, but generally speaking, anything we say or write is speech for purposes of the First Amendment unless it violates some boundary that the First Amendment will not protect, such as if it's obscene under the First Amendment's reasoning, or if it's a true threat, or fighting words, or some of these doctrines under First Amendment law.
So generally, for our listeners, we can assume that artwork is speech like the spoken word and is generally protected that way.
Yes, although it rests on a less firm foundation than verbal expression.
And also, to be clear, when we're talking about legally protected speech, we're talking about a relationship, right, between the government as censor and a private individual or group of individuals, right? I mean, what's the boundary in terms of the actors who are involved in terms of what's protected?
Yeah, so that's an important point, and I think it gets lost a lot, but the First Amendment only applies against the government. The First Amendment says Congress shall make no law. That's, of course, extended to the states as well. Private organizations can discriminate against speech based on its content all they want. It's simply the government that can't do that. And so censorship, in a legal sense, is really when the government is retaliating against or somehow prohibiting speech of its citizens.
Can the government censor its own speech?
No. Well, I mean, there is no such thing as censorship of its own speech because the government can. There's a doctrine called the government speech doctrine, which means the government can say anything it wants. The Supreme Court's really been building up recently in a case involving a public monument, the Sumum case, where the courts just said the First Amendment doesn't apply when the government is speaking on its own behalf. And there are no limits in that realm.
Right. And that was the case in the Richard Serra case a number of years ago where Richard Serra challenged the government's taking down of his site installation, Tilted Arc, in Federal Plaza in New York. And one of the arguments he raised was that it was a violation of his First Amendment rights. And the court said, you don't have that right. It's the government's work, and they have the right to display it or not.
Yeah, and interestingly, the Second Circuit was somewhat ahead of the Supreme Court in they didn't really have all the language of the government speech doctrine at their fingertips at that time because the doctrine evolved since then, but that was the principle. And I'll just add that a funny thing about that Serra case was that one of the reasons the court had trouble understanding his First Amendment claim goes back to this question of whether art is speech. They said, well, he can't give us a sort of clear statement of what the meaning of his artwork was. So why is this even speech? There was some question around that goes back to the question we were originally pushing on, which is, that difficulty of shoehorning art into this model of rational ideas on which free speech is grounded.
Right. So how do museums fit into this? And how do they not fit into it?
Yeah. So government museums, like the Smithsonian would be an example, are governed by the First Amendment, whereas private institutions, and we've seen several controversies recently involving private institutions, are not constrained by the First Amendment, generally speaking.
And those could be private institutions that are 501c3s and get a lot of their funding from the government, but have discretion over their curatorial output.
Yes, for example, the Whitney, which has been in the news a lot over controversies about speech, would be considered a private institution for purposes of the First Amendment and not constrained at all by law in terms of its decision to show or not to show a work of art.
How would that work if most exhibits receive funding and some receive government funding? So what would happen if the Whitney was showing a controversial piece which was sponsored through a grant from some government foundation or organization, and the government decided to withdraw the funding because they found the work displayed as offensive?
So that would get into this, I've talked about all the patchwork areas of the First Amendment. There is one area that has to do with government funding. And there was a famous case that you know about, of course, involving the Brooklyn Museum of Art, where then Mayor Giuliani, who's certainly in the news these days, tried to basically shut down the Brooklyn Museum of Art because he didn't like the art they were showing. And
Should we describe the piece briefly?
Yeah.
There was an exhibit, but one of the works that was objectionable among many, if I'm correct, was a Chris O'Feely piece that was depicting the Virgin Mary, but she was eclectically depicted and clad, and one of her breasts was exposed, and it was actually depicted in elephant dung, which is something O'Feely does regularly in a lot of his paintings, not just with this painting. And Giuliani's objection, and many other people's objections, was that it was disrespectful of religion.
Yes, exactly.
And he used the religious hook to go after the museum.
Absolutely. And he threatened the museum and said, you can't show these kinds of blasphemous works. And in that case, the Brooklyn Museum actually won in court because although it's a little murky what the lines are of government funding of art, Giuliani crossed it by singling out really what was a viewpoint, saying, you can't say this or I'm going to punish you. They said that looks too much like a violation of the First Amendment, and he lost that case in court. So there are limits on how much the government can control the speech in museums and the curator's speech in museums. But there's a lot more leeway for museums, even government museums, to make curatorial decisions that are not violating the First Amendment.
I think one of the sort of confusing aspects of this, or can seem confusing to people, is the government is free not to fund, right? And isn't that, in a way, censorship itself, what they choose to fund and what they don't? Like the New York City of Cultural Affairs, they're funding what they want to fund, and that actually has a great deal of impact on what speech gets out there.
This was in another case involving government funding. That was Justice Scalia's argument, in a way, that he said, if your funding is by its nature already selective, you're picking and choosing what kinds of stuff you like. You're choosing good art over bad art, or at least the NEA is supposedly doing so. You're choosing art over science. Why are we doing that? And so there are questions about how to think about funding in the First Amendment landscape, but the general rule that the court has come up with is that You're allowed much more leeway to pick and choose among ideas when you're funding speech than when you're threatening to send someone to jail for saying something that you don't like, that the government doesn't like. And so, it's a good question.
Is there a line between you're free to fund or not fund, but once you fund, I mean, this is what the Brooklyn Museum case seems to suggest, that once you fund, then your hands are kind of tied if you're a government actor.
That's absolutely right. I would say your hands are tied, but only at an extreme limit. I think what we see from the Finley case, which was a case that, I don't know if we want to give background on that or not.
Sure, I think it would be interesting because
Yeah.
it takes us back to the culture wars of the
Yeah.
1990s and was
Yeah.
really a case that was cited by the Giuliani administration in their argument.
Yeah.
So maybe you could give us a little bit of background on that.
Yeah, and it really does go back to the culture wars of the 1990s because it had to do with an amendment to the funding statute of the NEA that was passed in the wake of the controversy over government funding of two particularly controversial artists, Mapplethorpe and Serrano. And Congress passed a law. They were very upset about what they thought was this shocking elitist art funding going on and funding blasphemous and sexually offensive work.
Well, that was the Perfect Moment exhibit, the one that also featured at the Contemporary Art Museum in Cincinnati, what were viewed as homosexual, sadomasochistic
Which was
works.
typical for at least a large period of Mapplethorpe's photographic work.
Right. And Serrano's work was his Piss Christ,
Yeah.
which was a crucifix in his own urine.
Yeah, and both works caught the attention of the public, caught the attention of Congress, and led to basically a political firestorm. The Corcoran Gallery of Art actually decided to self-censor a Mapplethorpe exhibition that was wending its way there from Philadelphia because of all this controversy in Congress over funding.
And was that ever challenged?
No, because the decision,
Or could it be?
I don't think that's a First Amendment violation. I think, well, it's interesting. I don't know the answer to that question, but I never thought of that as a First Amendment violation, to choose not to show work in a museum. I don't think so. But what ended up happening, and in some ways it shows the multiple avenues that the First Amendment can travel with Mapplethorpe, is that first we had a debate in Congress. It led to the self-censorship issue with the Corcoran. It led to an obscenity prosecution in Cincinnati against a museum and its director, where a director was facing possible jail time for showing work, and also led to restrictions on funding debates that later were adjudicated by the Supreme Court in a case involving Karen Finley.
What was the result of that case? What did the court say?
Of the Mapplethorpe or of Finley?
Oh, I'm sorry, of the Finley
Of Finley.
case.
So in Finley, the court, I'm paraphrasing, was considering language amending the government funding of the arts statute under the NEA, in which it said, in making grant selections, that the NEA should take into consideration, in addition to artistic excellence, decency and respect for the diverse beliefs of the American people. And this was language that Congress came up with after several attempts that actually violated the First Amendment earlier to try to stamp out funding for people like Mapplethorpe and Serrano. But they did it in such a vague way that the Supreme Court actually said, oh, that doesn't mean anything. That just means you can take it into consideration, decency and respect, but you don't have to only fund work that's decent and respectful. And because it's only a consideration, you're allowed much more leeway in the realm of funding than you are in the realm of sending someone to jail for saying something you don't like. And so therefore, that's okay. So it shows that there's a significant leeway in the funding realm that we can have. And yet there's a backstop and a limit that the Brooklyn Museum case shows. When you actually say, you said something that I don't like and I am going to shut down your museum for it, that is when you've gone too far in the funding context.
But there's a big area in between where you can make discretionary decisions about what
Absolutely.
you fund and don't fund.
Absolutely. And what you can show and what you don't show. And curatorial choices, there's also a lot of leeway for that. There was an interesting case by Judge Posner involving a small government state college exhibition in which he said, we're not going to let a curator's decision to move art around or not show it or put it in a different part of the museum because it might be offensive. That's not a First Amendment violation. Otherwise, we're going to get too inside the business of museums. So that's another place where we see a tremendous amount of leeway for even government museums.
Can you talk a little bit about art on government property? Because there is this line of cases, right? Art in the courthouse that's been commissioned, or art in an office building. And there have been controversies, which I think can seem surprising to people. The government owns the building. Shouldn't they get to say what's there or not? But it's not that simple.
Yeah, well, to the extent it's deemed the government's own speech, then it does fall under this weird exception to the First Amendment where the government can say anything it wants.
Right. Or not say anything.
Or not say anything it wants, absolutely. Yeah.
Is that because they're not making a law prohibiting speech? They're just speaking? What's the rationale for that?
Well, I mean, I think if you really, it makes sense that we let the government speak on its own behalf all the time. Like on the 4th of July, the government can have a big 4th of July parade, and they don't have to also have a maybe King George wasn't so bad parade. You know, they're allowed to sort of take a side in a debate and
Sure.
promulgate their point of view all the time. We want the government to do that. The question is, would we want the government to suddenly erect monuments everywhere saying Democrats are evil? You know, we might, under this administration, you know, when a Republican administration's in power, then any limits to what they might say. And the Supreme Court, surprisingly, has said the First Amendment is not a limit there. It may be that there are other aspects of the Constitution that would limit it. And at the end of the day, the ballot box is the limit. You know, vote them out of office if you don't like the monuments they're erecting or the speech they're saying. But it's really an interesting place where there's hands off what the government says.
Now, there's situations in which the government creates a public forum or a limited public forum on its own property, where then those considerations change.
Yes, absolutely. If it's opened it up to free speech of others, not just its own speech, then absolutely. Then the rules of the First Amendment really apply, and it can't start picking and choosing among different viewpoints or speakers.
Which, you know, it's interesting 'cause you could see that incentivizing the government to not open up as much space because they don't know how they're then going to be restricted.
Yes, absolutely. And I mean, I think this is in the background, just to go back to funding for a second, they're thinking about the incentives in a lot of these cases. If we put too much restriction on the government in what it can fund, there's an incentive for the government just to say, I'm not funding anything. So I think, you know, these policy considerations also lurk in the background of some of these legal decisions.
Right. So in the 90s, we talked about the culture wars. There were a lot of controversial speech issues. There were issues with pornography, both from the left and the right. There was a call for, you know, debates about whether hate speech was constitutional, but also if it was right. And then the sort of religiously insulting speech that we talked about, Giuliani targeting at the Brooklyn Museum. I don't know if you can talk a little bit about how some of those issues in the 90s implicated the law in terms of censorship and art.
Yeah, so one big concern of basically right-wing conservatives was pornography and obscenity in art, and we talked about Mapplethorpe earlier. And
What's the difference between pornography and obscenity?
Oh, yeah, that's a good question. So pornography is, I guess, a colloquial term. Obscenity is a legal term of art that really indicates a realm of speech that is not protected by the First Amendment, that's no longer speech. It's a subset of pornography, and it's an increasingly small subset of pornography as we've seen a shift in the enforcement of obscenity law over the last 20 years.
Right. I think it's probably still most enforced in the area of child pornography.
Yes, which is a separate legal domain, and that's an area that's very, very vigorously enforced by the government, and it has been growing in terms of an area of government concern as the problem of child pornography has grown. Whereas obscenity law, which was once a very significant threat to free expression and to artists, particularly to writers over the course of our history, where many great works of literature were banned, Ulysses was banned, Lady Chatterley's Lover was banned, all of these things, has declined dramatically in importance. And part of it was just an overt decision made by the government to stop prosecuting obscenity very much and to focus, in fact, on child pornography as the more serious problem. And as a result, and concomitant with that, or at the same time as that, I should say, we went through a digital revolution and a sexual revolution, and we're now living in an almost unrecognizable society in terms of how porn-soaked we are compared to how we were even 20 years ago, let alone 40 years ago. And the Mapplethorpe case arose just as these shifts were beginning.
Yeah. So can you talk about some of the issues in the 90s? What were important censorship debates in the 90s, and to what extent were they
Yeah.
legal, other than the Giuliani example.
Yeah. So it was really, I think, positioned as a populist, Republican revulsion against the cultural elite, the art world imposing its offensive.
Sounds familiar.
Yeah, exactly.
But it does sort of resonate now.
It
Remember, there was
does.
Pat Buchanan was running for president
Absolutely.
and railing against this sort of godless, pornography-soaked, abortion-loving, a world of the Democrats.
Yes, and I think there was also in the background a lot of focus on race. There was a lot of focus on AIDS because it was a time of gay activism. It was a time of leftist activism through art. So people were using art to protest what was seen as the government's neglect to address AIDS, concerns about race and racism. And art became this highly politicized realm used by the left to make political points and targeted by the right as an example of elitist people being out of the mainstream, dictating to the working man, and worst of all, using government funds to stick their thumb in the, stick their thumb in the eye of the working guy. So that
Sounds so familiar.
Yeah, it really was. And so many different artists were targeted during this time by Congress or singled out as having crossed some line and being new poster children for how dreadful the cultural elite was.
How does the hate speech movement map onto that? Because it does seem like that adds a different level of complication and concerns about what some people would call speech, certainly pure speech, and then some forms of, expression that could be called speech, mostly from the left, right? And
Yeah.
did that have artistic implications, or do you think it could?
Yeah, so there's been a growing concern, and this is a very contemporary concern, that the First Amendment gives really robust protection to what we would call hate speech, meaning racist, vile, horrible speech. And this is a surprising thing to a lot of people. Why do we do that? And it's a place in which the U.S. is quite exceptional. Other countries don't do that. And the idea arose under the First Amendment that because we have such solicitude for political speech, hate speech is in some ways a version of that. It's a version of saying, I like this racial group and I don't like that racial group. How do we stop people from saying that and not get into the realm where we're suddenly policing other aspects of the marketplace of ideas, saying you can't say this political thing, but you can say that political thing. The First Amendment should be hands-off in expressing your viewpoint. And so the Supreme Court has concluded, say racist things within limits, but most of the time, all you want. And that is coming under fire from critics who think that the Supreme Court has underestimated the harms caused by racist hate speech. And I think we're seeing it on college campuses now and in many art controversies now where people are saying, wait a minute, there has to be some way to restrict this stuff. This can't just be a free-for-all. And although, as I mentioned, there are some First Amendment limits to this, they're really only at the fringes of hate speech.
Do you think these concerns, do they consider art in any special light? Or art is no longer special in the way that, the law has made art somewhat exceptional in certain areas, the First Amendment and privacy law, those are these movements hate speech, or let's say the Catherine McKinnon sort of view of pornography, which I think is very influential and important. Are they relatively unconcerned with art? Does art have any exceptional power in those arguments?
It's funny. Different critics of existing First Amendment law take different views about art. Catherine McKinnon, for example, who's the leading critic of what's considered the feminist anti-pornography movement, where she viewed pornography as a root cause of women's subjugation, said that she was particularly dismayed by the Supreme Court's obscenity jurisprudence, where it made exceptions for works of artistic value, because she said sometimes art is the worst thing. Allowing something through art, protecting art that is, in her view, sexist, gives it a special blessing. And so we should be less protective, if anything, of art, or be more concerned about the harms of art. But what's interesting to me in some of the current debates we're seeing around hateful speech or speech that's considered racist is how often art is being singled out as a target of people who are concerned about these issues. And I think there's an interesting subtext to me that art has a lot of power, a tremendous amount of symbolic power that makes people focus on it. So, for example, with the Dana Schutz controversy at the Whitney involving the painting of Emmett Till that was so offensive to so many people, I thought it was interesting that an artwork led to such extreme reaction. In some ways, to me, it's a testament to the power of the visual to communicate very broadly.
And one of the interesting things I think about these works, and the Dana Schutz example, is that her intent was not important in the analysis of that work for many people. I think in other controversies, the intent of the artist or the artist's own political views is important, and it says a lot about how people receive art. But in that example and some others, her intent, I mean, she's a far from conservative person, and that's been demonstrated over her career. You know, her intent was not relevant. It was just how the work was received.
It's so interesting because that's absolutely right. And I think, if anything, she was probably, it seems like she was intending to make that painting out of empathy, and empathy for Emmett Till's mother.
I think she said that as a mother.
Yeah, as a mother. But increasingly, there's this impatience with what did the artist mean, and this focus on, well, how does this work? How does this impact people? How does it feel to be on the receiving end of this work, regardless of what someone meant? And I think that was very much the view of the critics of Dana Schutz, who said, this is not your topic. Hands off. You know, this is you're not to touch this one. It's in some ways that it was sacred, I think.
Right. And there was also a lot of argument about that it was a commoditization of pain being inflicted on black bodies in particular, and that was improper.
Yeah, and so Parker Bright, one of the protesters around that, said, you know, this is a Black Death spectacle. And Hannah Black, another person, the person who began the critique of the Whitney for showing this work and called for the destruction of the work, said, you know, you can't use this topic, and her line was, for fun and profit. And so it was seen as this irreverent plaything, regardless of the fact that she had, as you had said, intended quite a different meaning to the work.
Right. And I guess, to be fair, in that respect, her identity was 100% the only issue, because as a white woman, that was why it was not appropriate for her in the eyes of these critics. While the Whitney, that biennial was very political and actually had a lot of art that was talking about injustice and racism.
Yeah. And, you know, there was a painting by Henry Taylor, who's an African-American artist, in the same biennial, showing very painful scene, the recent scene of the shooting of Philando Castile, and showing him bloodied in his car.
I found that very moving and disturbing.
It was a very disturbing picture, but it was not the focus of complaints, as was the Dana Schutz. And I think it goes back to this idea that increasingly there's concerns about what people would call cultural appropriation. This is not your topic. You're not allowed to do this as a person who doesn't have a connection to this history of victimization. And, you know, I think a lot of people have, probably particularly older people, have been concerned about this new way of thinking about art and politics.
Right. I do think there is a kind of an age gap there to some extent. You know, I'm of the age, I remember very vividly the Nazi march in Skokie and the decision of the ACLU at the time to defend the Nazis, which was very controversial, and as was the decision of their local chapter to defend the marchers in Charlottesville recently. And that, I think, created a lot of controversy even within the organization today, because there are so many different aspects of social justice that the ACLU is looking at, and there is a tension often between what we view as sort of pure First Amendment rights and other aspects of social justice. And I think sometimes you see that younger people are on the other side of that divide.
The assumption among a lot of younger people, and I think critics of traditional First Amendment values, is that what you're describing is really a tension between equality and freedom of expression. And what's funny is that for an older generation, and I think I'll probably put myself in that camp.
I was going to say, where are we drawing this line?
I know where I am in this room, so you're...
that I grew up on this idea that freedom of expression was the only way to get to equality.
Right.
That otherwise the government would suddenly say, "Oh yeah, we'll give free speech to you know, powerful white guys, and we'll shut down the minorities we don't like." And in some ways, that was what was happening in the culture wars when the government was, of the 90s, when the government was saying, "We don't like you AIDS activist, race activist, feminist activist speakers, or, what we perceive as blasphemous speakers. We're going to try to shut you down." And so I came of age, and I got out of law school and at that moment, where I thought of the government as trying to squash people who were advocating for equality, and those people on the left using the banner of free speech to protect themselves. And the politics have really flipped in this generation in a very interesting way.
Well, even before the 90s, right? I mean, directly preceded by the Cold War, in which Western countries with free speech values, quote unquote, were watching and felt a great risk of countries who did not have any value on free speech at all. It was out in the open that you couldn't say what you wanted. And so I think there were decades of people watching that and feeling like that wasn't okay. And then, I guess before that, you have civil rights activists and people who are really starting for the first time to protest, to use their physical bodies as speech in a way that really was profound in this country. So
yes, and I'm glad you brought that up, because I'm just thinking about the art controversies.
I wasn't
long
alive,
history.
just for our
We're not that old.
listeners.
but yeah, and I think it's the other funny thing about the politics of the moment is that we're living with a president who is, I think, not such a free speech kind of guy.
Only his speech. I mean,
yeah. I mean, he's
not everyone else's.
Yeah, he's I think much more open to ideas of limiting speech and expressing admiration for countries that do limit speech and things like that. And so it's interesting that at the same time the left is having these doubts about whether free speech is the enemy of equality. We also see a government on the right that has some antipathy towards free speech. So it's now under fire from a lot of different sides in the political landscape.
And it's interesting how art finds itself in the middle of these fights.
So another interesting sort of cultural or political and cultural event of these times is the tearing down of monuments and statues, particularly in the Confederate South. And, I mean, do you think that, based on what you said before, that the government is entitled to take down whatever monuments that are on its property without a violation of the First Amendment, or is there some First Amendment or censorship going on there, even if we all agree that it may be a worthy thing to do?
Who are the interested parties in that?
Yeah, so I think I'm afraid to speak too globally, because I think it would depend on the facts of a particular monument and who owned it and so forth. But certainly if the monument is deemed to be the government's own speech, then the government can take it down unquestionably under the government speech doctrine. There is no obligation for the government to say anything it doesn't want to say, and it can always change its mind.
Would that include works that the government commissions or that is commissioned by someone else but then given to the government?
Yes, privately commissioned monuments that are then donated to the government become government speech. So there's no legal barrier to it, but it's raises all kinds of ethical and moral and other kinds of political questions. And I also think it's a testament to the power, again, of the visual and how it rallies us and captures our imagination.
Yeah, it is. I mean, it raises the hypothetical, for example, of this current administration deciding that it wanted to take down all statues of Democratic or progressive political figures. And
which, by the way, no one has suggested is happening. Just not to scare our audience.
But I suppose, it could do so without implicating the First Amendment if they were statues or monuments that were government-owned on government property. And again, that's just a form of their own political speech that they're entitled to.
Whether this would have to be run through the democratic process is, one question that might arise. But ultimately, politics would be the backstop to that, not the First Amendment.
Although, in an interesting way, the First Amendment is what also protects us from that, because it gives people the right to protest and be loud about how horrible it is, and to bring their political persuasion to bear.
And I think there would be such an uproar that that's an example of how, even though the government might technically have the power to do it, that might be crossing a line, a political line.
So another controversy that I just thought we would throw out for you, since we like to talk about controversial things with you, is decisions lately to cancel exhibits of particular artists who have been caught up in allegations of sexual misconduct. Chuck Close is one.
Nick
Thomas
Nixon.
Roma, I think, was another. And one of them was the National Gallery, which I guess would also be viewed as a government institution. Any First Amendment issues there?
The National Gallery technically said it was postponing
Yes,
the show, so I don't think it's a First Amendment violation, but I have qualms about that decision. I worry about getting into a microscopic examination of the moral character of an artist and trying to invest art with that and judge art based on how pure or impure the artist was. I mean,
We're going to lose a lot of art in
we're
our
going to lose
history.
a lot of art. I mean, we could think, Caravaggio was supposedly a murderer, and I think
Straight
he's
through Picasso.
yeah, right. And so I don't personally like to think about art as too deeply entwined with the moral character of the artist. I'd like to make a separation, but that's maybe an old-fashioned point of view right now, where we're really seeing that, certainly not just in art, but in other realms, like where we're seeing, other people who've been felled by the Me Too movement, Louis C.K., Kevin Spacey, they're being actually, Kevin Spacey was actually erased
Yes.
from a movie. And I mean, I understand, maybe it's a business decision, but I would tend to say, let's punish or not punish a person for his misdeeds and treat the art separately. There may be exceptions to that in extreme cases that would perhaps make me reconsider, but these are not they.
And legally, I think there may be some confusion about the difference between censorship of art because of its content and because of the person who makes it. Now, is it the case that there is no First Amendment protection if you take down work because you don't like something the author did, even if it has nothing to do with the content of the work itself?
Well, I'm trying to think of an actual case where the government has done this, and I can't think of one, although...
This is a thought experiment.
Yeah, a thought experiment. To the extent that you could say that the artwork was being targeted because it represented an idea, or, anything that's made by Chuck Close is sexist. That would certainly violate the First Amendment if the government were to say we're no longer, showing your work, because the government isn't allowed to choose on those regards, or certainly send Chuck Close to jail for his artwork because it determined it was sexist. But it could, Chuck Close is not an example of this, because I don't think that anything he did would have crossed a legal line, or crossed what for some people has been considered an ethical line. But, someone who's actually commits sexual assault can certainly go to jail. But I don't think you can then the government could not therefore round up his artwork in the way that the public sphere has suggested we remove it in a private way.
Right.
I think it's interesting because just the destruction of art, or the suggestion of the destruction of art, is such a powerful thing. And I don't know, where that comes from historically, but I think even in the Dana Schutz controversy that we were talking about, a lot of people were, there were a lot of sort of interesting and provocative things being said about the piece, and I think a lively discussion. But then when the call was made to destroy the work, I think that people just started to focus on that. And there was another example recently. If you compare it to even, what happened at the Guggenheim and the animal rights protests, they decided to remove several works, which I think was maybe greeted with a little less apprehension.
Yeah, I think, how should we deal with controversial speech? Should we just destroy? This is a question for the monuments as well as for these examples of controversial art. Should we destroy it outright? Should we remove it from public view but preserve it? Should we keep it on view but have
contextualize
it, have labels? Should we commission counter speech? This is a really interesting argument that I think I'd like to pursue in the realm of the monuments controversies, where Brian Stevenson, who was
just going to say that,
this magnificent, I'm proud that, to be associated with NYU Law School, where he's a law professor, has just, through his Equal Justice Initiative, opened the National Monument to a lynching memorial. And one thing that he has created through that is an opportunity for communities where lynchings have occurred to actually erect markers to those spots. And he has said, our southern landscape is littered with monuments to the Confederacy and to white supremacy. Where are the markers of the victims of lynching? And I think this is, to me, a very sort of beautiful approach, in that it's one that I recognize as being infused with a First Amendment ethos, which
it feels very American.
Yeah, very American. Like we're going to counter your horrible, offensive speech with more speech on our side and create this rich and robust marketplace of ideas and that's the old-fashioned First Amendment idea. More speech is the solution to society's ills. And yet, for a lot of people, we talked about this with Dana Schutz, there's an impatience with that. No, take it down. It's too painful to have it up. It's too strong a message sent by the government. And, there may be occasions where that's also correct. So, I think we're going to see a complex working out of multiple solutions to this problem of how we remember our own history.
So in the case of art museums, though, for the Whitney and the Guggenheim who did take down work, or Sam Durant, who's had a sculpture at the Walker Art Center, those are not legal issues, but they still feel like they have tremendous cultural significance, which just goes to show that censorship can be a really powerful and real social force, even if the law doesn't get involved.
Yeah, and I think, one place that people can look to in trying to sort out what are not technically legal controversies is to the rich body of First Amendment jurisprudence and scholarship and thinking on these questions, because all of these policies have been exhaustively considered by lawyers and judges.
So as you've heard today, these are complicated issues. And art, as it always has, seems to carry the weight of so many social agendas and dissatisfactions. In that way, it is ever polarizing, often the subject of attempted censure, and ever so important.
And that's it for today's podcast. Please subscribe to us on iTunes or wherever you get your podcasts, and send us feedback at podcast@schlaw.com. And if you like what you hear, give us a 5-star rating. And finally, we want to thank our fabulous producer, Jackie Santos, for making us sound so good.
Until next time, I'm Katie Wilson-Milne.
And I'm Steve Schindler, bringing you the Art Law Podcast, a podcast exploring the places where art intersects with and interferes with the law.
And vice versa.